Good morning, good afternoon. This is Saul Ancona from Coin Council Law Firm. I'm here to introduce my AI assistant who's going to give you some information on crypto fraud and how you can protect yourself. I hope you enjoy. Thanks. Today we are going to discuss crypto fraud on exchanges, how these losses actually occur, and how victims can pursue and obtain compensation even when exchanges deny responsibility. This explanation is based not on theory, but on sworn testimony, forensic evidence, expert analysis, and a fully litigated arbitration award issued by the American Arbitration Association, where an exchange was held liable for a large-scale account takeover and forced to pay restitution, damages, attorney's fees, and costs. Section 1. How crypto fraud really happens. Most crypto theft today does not occur through technical hacking of blockchains or brute force attacks on private keys. The dominant method is account takeover through social engineering. In these cases, attackers impersonate exchange support personnel. They already possess sensitive customer information such as account balances, transaction history, partial social security numbers, internal account flags, or support ticket details. That information is what makes the scam credible. Once access is obtained, assets are rapidly liquidated, consolidated into major cryptocurrencies, and moved through overseas platforms, swap services, or privacy protocols. The theft often completes in minutes. This is not speculation. This exact pattern was established through evidence in a 3-day evidentiary hearing before an AAA arbitrator, December 11th, 2025, arbitrator Ruffalo. Section 2. The exchange response pattern. When victims report these losses, exchanges typically respond with a standard script. They claim the user must have shared credentials. They claim their security exceeds industry standards. They point to liability disclaimers in user agreements. They refuse to investigate the root cause of the loss. In the arbitration award referenced here, those defenses were tested under oath. The arbitrator found that the exchange had outsourced customer support to overseas contractors and granted them access to highly sensitive customer data, including account balances. That decision created the conditions for targeted fraud against high-value accounts. Even more significant, the exchange failed to conduct any meaningful investigation after the theft occurred. No forensic review. No root cause analysis. No determination of whether insider data had been compromised. The arbitrator concluded that this conduct amounted to gross negligence, defined under California law as a want of even scant care. December 11th, 2025, arbitrator Ruffalo. Section 3. Why disclaimers do not shut down liability. Victims are often told that user agreements eliminate all responsibility. That is incorrect. Contractual disclaimers do not protect an exchange from liability arising from gross negligence, breach of contract, misrepresentation, or breach of fiduciary duty. In this case, the exchange's own privacy policy promised bank-level security, fraud prevention, and secure handling of personal information. Those promises were incorporated into the user agreement. The arbitrator found that oversharing customer data, failing to secure that data, and ignoring obvious risk signals breached both the contract and the implied covenant of good faith. Because the exchange acted as a custodian and agent when executing trades, it also owed fiduciary duties, which were breached when it allowed clearly anomalous transactions to proceed while collecting transaction fees. Section 4. Technical failures that matter. Legally, expert testimony established that over 95% of account takeovers originate from compromised email accounts, not compromised phones. Despite this, the exchange relied almost entirely on email alerts during high-risk activity, even though those emails were likely intercepted by the attacker. Mass liquidations, new trading interfaces never used by the customer, and large outbound transfers were incorrectly rated as low risk by the exchange's systems. These failures were proven through transaction logs, risk models, and expert analysis. This is why evidence matters, and this is why victims with proper forensic support can succeed. Section 5. Compensation is real. The outcome of the arbitration is critical. The arbitrator ordered full restitution of the stolen cryptocurrency value, additional compensation for loss of use of funds, attorney's fees, and costs. Confidentiality was denied. The arbitrator explicitly stated that the exchange's refusal to investigate appeared designed to evade accountability, a finding no reputable asset custodian should accept. December 11th, 2025, arbitrator Ruffalo. This matters because arbitration awards are enforceable. They establish accountability, and they demonstrate that exchanges are not beyond the reach of law. Section 6. What victims should do. Victims of crypto fraud should act deliberately. Preserve transaction hashes, timestamps, IP logs, and communications. Document all interactions with the exchange. Do not accept blanket denials without scrutiny. Understand whether claims arise from negligence, breach of contract, misrepresentation, or custodial failure. Most importantly, do not assume the exchange's narrative is accurate. Closing crypto did not eliminate responsibility. It changed its form. Exchanges that custody assets, control security systems, and market trust cannot abdicate their duties when fraud occurs. When they do, the law provides remedies. The arbitration award discussed here proves that compensation is not theoretical. It is achievable, enforceable, and grounded in evidence. If you were told there is nothing you can do, understand this clearly. That is not a legal conclusion. That is a strategy. Well, I hope you enjoyed that dissertation by my AI assistant. I appreciate you watching. And of course, the whole point of this is to help people. So if you need help, please reach out to Coin Counsel.